Good morning. It's 7:50 on the ticket. You got the morning musers. And from time to time, we get stuck on this show. And we always say, man, I wish we had an expert in this particular field. And it seems to happen a lot when we're talking about a court case. So a few weeks ago, we thought a criminal defense attorney roundtable would be awesome. And that's what we have for you this morning. Joining us in studio are three criminal defense attorneys. Todd Shapiro, 20-year attorney based in Plano. Morning, Todd.
Morning. He's only 20 years old.
No, he's been an attorney for 20 years. Yeah. Heather Barbary, who has been an attorney for 22 years, also based in Plano. Morning, Heather.
Good morning.
And Joe Padian, a 26-year veteran of being an attorney here in Dallas. Morning, Joe.
Morning.
And you went to Jesuit, right?
I did.
Okay, we have some Jordan Spieth questions to get to at some point.
Oh, Lord.
All right, Gordo, you're the one that seems to bring up these questions so often.
Yeah, I always have so many questions about the mind of the criminal defense attorney and how you balance your personal feelings with your profession. Do you, and this is open to whoever speaks first,
All right, I'll start. No, I'm kidding.
do you want to know if your client is guilty or innocent? Does that help you in how you present the defense? Or would you rather have the plausible deniability and you have to play that in your own mind in order to remain enthused?
Well, as we were talking before we came in here, we knew that was going to be the first question.
Correct.
We all discussed that was going to be the first question, and we all also agreed on the same answer, right?
Right.
How
Correct.
would we ever know if our client was guilty unless we were there when the alleged crime took place?
Isn't that kind of a workaround if
No.
they flat out tell you they did it?
Yeah, don't you have the heart-to-heart with them to say, okay, level with me?
Or do you tell them, hey, I don't want you to answer this definitively for me. I just want you to work with me on exculpatory things.
I would say the majority of the time, for me at least, and they probably would agree, we know right off the bat whether they quote unquote did it or did not do it very quickly from the beginning.
And is that a personal thing that is that an intuition, or do you ask them directly?
I ask them, I think both really. And our strategy defense wise is based upon that initial meeting to determine, are we going to try to beat the charge? Are we going to try to fight the case and win by going to trial, or are we going to try to mitigate the damage going forward to try to lessen the impact on an individual's life?
Mm-hmm.
I'm a little different in that regard. I do not ask off the bat. Oftentimes, I will see what evidence the government has and then see what defenses we can develop. And if there's no need for the defendant to explain or discuss their role in it because the evidence is insufficient to establish guilt beyond a reasonable doubt, then it might be better not to have certain information from the defendant if we're going to rely on witnesses who come in and say certain things on the stand. You certainly don't want contradictory statements from different witnesses, including the defendant, prior to trial. So I tended to let it develop a little bit before I want the answer to the question of whether you did it or not. But oftentimes towards the end of the preparation, it's necessary to know what happened or what their role was.
Heather's just
And
dying
I
to
know.
talk. Go ahead, go.
And I'm a little different from both of the gentlemen. Sometimes when people come in and they say, okay, I'm guilty of it, I'm like, I know you're kidding right now, because if you were telling me and confessing to me that you're guilty, then we couldn't go forward on the case and really say that you're innocent, right? They're like, yeah. So sometimes you don't have to actually pull all of their confessions from their deep dark secrets out.
So you said we don't have to go forward with the case. Have you ever, any of you, had a moment or a client where they said, yeah, I'm guilty, I committed this, whatever the crime was, and you said, then I cannot represent you?
Never.
No.
Never.
Ever.
So you're just BSing with the accused then when you say...
That's a harsh word.
when you say, well, you didn't really do it, right? You're innocent.
It's just like, for instance, if somebody comes in and they confess to doing anything that's perverted with a minor, can I say that?
Sure, of course.
Okay.
Mm-hmm. Well,
You have to report it.
Say everything.
you have a duty to report.
Okay.
So sometimes
Even if you're their lawyer.
even if you're their lawyer. So that it puts a whole wrench into it. And I do some of those types of cases.
Morally, how many times do you just say, okay, I'm not, this is too much. I'm not going
never.
to.
Never.
Yeah.
Never. Ever.
Unless they're complete pain.
Uh-huh.
Well, and remember, the standard is not innocent. It's guilty or not guilty. So the way the system is set up is the government has to prove the case beyond a reasonable doubt. It's not whether the person did it or not. It's whether the government can prove with their evidence that the person committed the offense beyond a reasonable doubt.
And it seems like to me this is where wording really factors into it, and it's kind of muddied the waters for a lot of us people who aren't attorneys. And there's another system, I don't know whether it's in Britain or Scotland or somewhere else, where it's worded as proven or not proven rather than this guilty or innocent. Because when we hear guilty or innocent, we think of it, well, did the person do it or not do it? Whereas if it was worded in the public consciousness as in proven or not proven, that makes more sense to us, because that's really what we're talking about in the court of law, is whether they have proven the case or not proven the case, not whether the person is actually guilty or actually innocent.
Well, you got to take the word innocent out of your vocabulary, because that's not a word that's used in our court system. It's guilty or not guilty. So when a jury decides a verdict, they're only given two options, essentially, on the verdict form: guilty or not guilty. The word innocent doesn't appear on a verdict.
Right. That's something that we in the media and in the public do afterwards, say he was proven innocent.
That's correct. That word's not part of our vocabulary.
Okay, so if you've never backed out of a case because you knew that your client did it, and by the way, have you done a lot of murder cases? Have you defended a lot of clients who killed somebody?
I have, not a lot, but I have defended clients for murder. Yeah.
So I guess on the outside looking in, we always wonder if the accused is clearly guilty. Everybody knows it. And in the courtroom, you have the family of the victim, and they're crying. And we always wonder, how can the attorney go in every day and defend somebody that they know did it? How do you do that? How do you make that work? Like, when you go home at night, do you have to have a double and say, man, this is really tough because I know this guy did it, and I see the victim's family, and it's just tearing me up to have to defend this person?
I think a lot of times for me, I'll go through the car wash and roll the windows down and just cleanse myself.
Try to clean yourself of that sin.
It's hard. It's difficult.
Yeah.
For all of us, it's something that requires, I think we would agree, a special personality to do, and that's why not everybody does it. It's tough. You try to separate yourself personally and your family and your everyday life from your professional life. You have a job to do, and you go in and do it to the very best of your ability. You represent your client zealously, morally, the best you can, and you do everything you can, and then you go home at night, and that's what you do. And you get up the next day and you do it again, and that's your job. And that's what we do, right?
Right.
Yeah, correct.
I mean, it's not that I take great joy in giving a blistering cross-examination to an elderly woman, but these are the things that we have to do in order to defend them. And we have to kind of have that laser focus on the client, and making the state prove it beyond a reasonable doubt.
And all of this is, I guess you square it in your head, because you have to believe in this adversarial system so much, and that this is the way that justice is best served by you being so, zealous in your defense of someone and doing blistering cross-examinations of sweet elderly witness there and that. But if we were to start over and start from scratch, is there a better system than an adversarial system? Like, are there any examples of a collaborative type of justice that tries to set the world right?
Well, I don't know if this is a direct answer to your question or not, but most cases plea out. There's a negotiated plea on most cases. There's a single-digit percentage usually of cases that actually go to trial. So most people plead
single
guilty.
Digit. That's
For
amazing.
Sure.
Yeah.
For sure.
Yeah.
Yeah, and so most people plead guilty, so they are negotiated out.
But isn't that sometimes kind of a form of injustice too? By you have the huge grinding machine coming down on someone who may actually be innocent, and they plead out because they're like, I can't I'd rather have the lesser charge and not fight this than I just can't go through this when I have the entire government coming down on me.
That
on
happens.
This.
That happens a lot. I wouldn't say most cases, but that does happen when people take pleas because the consequences are so great. They don't want to risk the chance of going to prison for a lot longer, even though they may not have committed the offense. If they're looking at 2 years in prison as opposed to life, if they plead guilty to something the government may or may not be able to prove, or they didn't do, even worse, some people opt to take the 2 years because they don't want to risk that. But that does happen. That's just the system. In response to your question about if we could start over, I think we've developed this system over years and years of, the Commonwealth and the British Empire, the way they did it forever. I think we've kind of honed it down in this country to the best so far that we've been able to get it, where the government is required to prove beyond a reasonable doubt an accusation that they make. It's not flawless. There are people who get stuck in the system unjustly, but like with everything else that humans get involved in, it's the best we can do, I think, so far.
Well, that brings up another interesting twist in this. Is it harder for you to represent somebody that you know is guilty, let's say of a very heinous crime, or does it keep you up at night more representing somebody that you know is innocent, but you're going to have a really hard time proving that?
The second one for sure.
Easily.
Innocent.
The second one.
Really?
No question. When we know someone didn't do it, and we are tasked with the idea of their life is in our hands, and the families come to us and said, please save my husband, my child, my spouse. We are putting all our faith in you to win this case. And we know in our hearts that that they did not commit the crime. I believe that's a much more difficult, emotionally, psychological task for us than when we know someone's guilty. Because if they're found guilty and they get what's coming to them, I think we can certainly
sleep at night.
Right. And we're at peace with what happens because they get what's coming to them, and we're a spoke in the wheel for sure. But if someone is then convicted when we know they didn't do it, I think that's much more difficult for us.
You keep up with records? Do we see like a win-loss thing for y'all? Do you even know what your record is?
What's a loss? We don't lose. I don't think
you're all undefeated, right? You all had some sort of victory.
None of us ever lost. That's right.
What percentage of clients that you've had do you really feel that were guilt-free? Like they did not do it? This is a mistaken
allegation?
Yeah.
It's a 25%.
I'd say probably in that neighborhood. Yeah, I'd say somewhere in that range. 25 is probably about right. And again, you're thinking
that's
about
troublingly high to
the
me.
range of crime, though, right? I mean, you're talking about traffic tickets up to capital murder. I mean, theft, DWI, smaller things all the way up to rape, robbery, murder. That's a large range of stuff.
So drill down a little bit more on that.
Okay.
What in big cases, like when you're talking about assaults and rapes and murders, what percentage of those do you feel are mistaken identity, or the person is innocent of this particular charge?
Well, you've also got self-defense that comes into play. So they may have committed the murder, but they've got a defense that could actually get them off of the charges altogether. But I would say innocent. Murders, assaults, rapists. Did you throw that in there too?
Sexual assault is a lot higher.
I would still stick with the you almost have to separate them out for the sexual assault.
Okay, sexual assault. There's more
actual
falsely accused sexual assault.
For sure.
Yes.
Wow.
I would say more like definitely the 25 to 30% range for those, and probably more like 15 to 20% maybe for the assaults and murders.
The sexual assault brings in different motivations when you've got, because normally you've got people that know each other, and you've got, let's say, family relationships, and there could be some motivation between why someone may make an allegation against someone, whether it's stepdaughter on stepfather, whether it's, whatever the relationship between the parties may be that may not exist in other cases. So I think the false allegation is much more prevalent in a sex offense.
And date rape,
things like that. than it would be in other situations.
Heather, did you have something else you wanted to add a couple minutes ago about the difficulty of defending somebody who you know is innocent? Yeah.
Yeah, I do. It's
and not being able to prove it.
Yeah, absolutely. It's that, hoping to God you can prove it, right?
Right.
But it's waking up at 3:00 in the morning with that heartburn. And it's wondering, am I doing everything I can? And they're looking you in the eye, totally vulnerable, knowing they're trusting you. And so that's a whole different type of pressure. They're looking at you saying, can you save my life? Mm-hmm. Like, yes, is the right answer. And, it's just a matter of getting to the yes. Yes, I can. And yes, I'm going to do everything I can. And it's just, it's almost like a promise to yourself to follow through and commit to this person, do everything you possibly can. And if you do that, then you know that you've done everything you can, and hopefully it turns out the right way.
Do you have a lot of cases where your client gets really upset with you because they don't think that you're representing them to the fullest of your capabilities?
If any of my clients are listening right now, sometimes.
Yes, that happens.
And you're doing your best and within the letter of the law, and that must be a very difficult situation to handle. And it probably, I'm sure it's come up a lot in the courtroom, like when the client leans over to you and says, "Hey, what are you doing here?" And you have to be nice to him, but you also have to say, "I'm the expert here, right? I know what I'm doing."
Yes, absolutely. It happens more often than any of us want it to happen.
Really?
But, yes, and it is very frustrating when it does happen, especially in the courtroom. Extremely frustrating when you're doing everything you can. You've got a plan, and things sometimes are going well, and then you've got this person in your ear complaining.
Or they're telling you, "Hey, this guy in my cell told me that I should really file a motion to suppress in this case." You're like, "Oh,
now all of a sudden
great.
The guy in the cell is running the whole thing.
Right, yes.
The jailhouse
and
lawyer.
that happens a lot.
And he's in there because of what?
Yeah.
Mm-hmm.
Yeah. Or the internet lawyer, I read that this is what we should be doing on the internet. Oh,
Right.
That's
That sounds
wonderful.
good.
Thanks for reading.
Has the defendant ever stood up in the middle of the trial and said, "Your Honor, I'd like to start representing myself
That's right.
from this point forward"?
Right. Exactly.
We always laugh at sports movies because they're not very accurate. When you watch a movie, and that's our peek into your world, movies and TV, how accurate is it, or is it laughable when you watch a movie about a high-profile criminal case?
My Cousin Vinny.
Yeah. How real is that? Would that have worked?
Actually, some
Joe
of the
Pesci?
things in My Cousin Vinny actually are legit.
Some of the stuff occasionally is somewhat, some of the cross-examination maybe. The funny thing is that's what people see on TV and in the movies, and that's what they expect in their trials. And so from a dramatic effect, it's almost like you've got to give them that during a trial. You've got to almost act out what they're expecting to see.
Really?
A little bit. They want to see the theatrics inside a courtroom. That's what people are almost expecting. I like watching, courtroom dramas on TV and in the movies. It's exciting to me, but it's not realistic. No.
It annoys me so much when I see lawyers being overly dramatic in the courtroom. That just drives me crazy. Because to me, the most impressive ones are the guys who are just kind of, they have that real understated thing, but they're just surgeons eviscerating the prosecution up there in the most understated manner, which makes them seem like they're so in control. I can't get the answer from the witness and then turning to the jury and laying to them like, "Oh my God, everyone heard that, right?"
Y'all do that? You do the big...
No.
There's slamming of the counter.
There's certainly a time and a place for all of it, and in closing argument, but when you're questioning witnesses, it's not nearly like you would see on TV. You're not just Your Honor, and you're just going bananas.
Did you order the code red?
Right, exactly right.
Okay, one question is juries versus judges. Does our jury system tend to get it right more than it would be if we just had professional jurists that decide these things?
That's a great question, and that's a question that we should address and have them answer next when our criminal defense lawyer roundtable We're in the middle of our criminal defense attorney roundtable. We've come up over the years with so many questions during Muse in the News about why a lawyer would do this or what happens in a courtroom in this case. And so we've assembled our roundtable, 3 veteran area lawyers, Todd Shapiro, Heather Barberi, and Joe Padian. And we thank you all for your time. This has been great. And we talked in the last segment about defending the really guilty and how hard that is, and defending the really innocent when it's a tough call. And that's all interesting stuff. But Gordo, before the break, you asked a really interesting question that's going to get us into another area.
I've always wondered if the criminal defense attorney or prosecutors, and maybe there's a difference of opinion depending on which category you're in, as to whether juries are a better idea than just having a judge, a professional jurist up there making the decision on guilt or innocence of a person. Because to me, on the outside of it, it seems like juries is a worse idea, because juries oftentimes are so swayed by the emotion of a case, they won't focus on the facts of the case, or they will focus to it on the emotion to the exclusion of the facts, or to the diminishment of the facts. And I see this oftentimes with prosecutors who want to talk about the crime in almost like fine detail to go over the horribleness of it. Whether we're not in here to create a huge emotional reaction on the horribleness of the crime, we're here to try to determine whether this person actually did this thing or not. But when you get a jury all worked up emotionally about what a horrible crime it is, that emotion wants to be placed somewhere and centered on something. And the best thing to center it on is somewhere in this room, and why I ought to go over to that guy right over there that's sitting on trial because he's having to defend himself for this charge. That somebody must have done something right if he's the guy sitting here. And so you have a tendency to overweight the evidence against the person because you're so emotionally wound up by the actual crime itself. So anyway, that was my take as an outsider. What's the criminal defense attorney's opinion on juries better than a judge deciding?
That's a great question, and I think the three of us would agree that all the judges we are in front of would be fair and impartial and excellent for every case that we handle. But a couple things. The judges, federal judges are appointed for life. The judges on the state benches are elected. Mm-hmm. So you kind of have to think about that, the consequences of a decision a judge makes for instance, in a heinous crime to which you referred earlier. So you've got that. The other
so
thing
that they aren't really impartial by the fact that they're elected. They have to be able to point to something, and they have to do the whole, I'm the only one that's so tough on crime.
Yeah.
And you never look tough on crime if you're finding someone not guilty.
Yeah, that's something to be considered when deciding whether to go to a judge or a jury. It's just the reality of it. And the other thing is, judges call balls and strikes. That's their job most of the time, to sustain or overrule objections, to grant motions, things like that. So while they are detached emotionally most of the time, they hear thousands of cases. So when you're talking about a defendant who is trying to raise reasonable doubt as to whether he or she committed a crime, sometimes it is better to have some emotion in it, because the jury can then determine the credibility. Credibility is huge in a trial, the witness's credibility. And so if people are testifying, you want people who come in with their life experiences to hear that testimony and make a determination as to whether that's actually credible, that makes sense, whether that witness has a motive to be testifying against the defendant. All those things come into play. And then finally, all I'll say is that's why there's 6 jurors in a misdemeanor and 12 in a felony case, because you don't want to leave one juror with the decision of whether someone's guilty or innocent. Sorry, guilty or not guilty. You want them to go deliberate. And if you have 12 people in a felony, for instance, who bring their life experiences and their ability to determine if someone's telling the truth to them or not based on those life experiences, you want them to go back and deliberate. And that, to me, seems to be the best way we've come up with it.
The wisdom of the crowd.
Correct.
Tends to win the day.
Yeah, I would dovetail off of what Joe said, but much briefer. I think that we're going to go to...
Whoa,
thanks, Heather.
That was a shot.
And but the legal issues I would take to the judge, but when it's a factual dispute or credibility of the witnesses, that's my time for a jury. Sure. Because we can uncover things that would impeach them, when we cross-examine them, the adversarial witnesses. And so that's what I would do.
And certainly I agree with the idea that these judges are elected. And when you're talking about the heinous crimes, that's tough for a judge that's got to be up for re-election in a year or 2 years to find someone not guilty of let's say, a highly publicized case, and everybody's watching, their eyeballs everywhere, and they find somebody not guilty, and that could be used as something against them down the road. And that look, they're human, and they want to keep their job. So that could have an impact. Secondly, each side, state and defense, is guaranteed a right to a jury trial. So the only way we ever get a case in front of a judge is if both sides agree to waive a jury and take the case directly to the judge.
And would you ever advise that?
Absolutely. We do it all the time. It just depends on the case, depends on the court in which the case has been assigned. I mean, we all know every judge that we're in front of, so we know their tendencies, we know what they like, we know what they don't like. So if we're in a friendlier court versus an unfriendly court, that will impact the advice that we give our clients.
When we have a high-profile case here that, like, we talk about on our show, do you all tend to follow those really closely and play armchair quarterback, or do you not have time?
I do.
We certainly do, yeah.
Yeah, we follow them. I don't think the three of us play armchair quarterback on them ever. It is so hard to make a judgment about how a lawyer is doing during one of those trials, because there's a million things going on at once in those courtrooms that we're not privy to,
and we're only catching a snapshot. If we are flying by and we've got other business in the courthouse, we may stop in for 10 minutes and just kind of see how things are going. And we know all the lawyers that are involved. We heard y'all talking a week or two ago about the capital murder trial that's going on in Collin County. You were mentioning Bubba King, who's the lawyer on that case.
I had a lot of people respond to me on that because I was making fun of the name Bubba, and everybody was like,
fantastic.
dude, he's awesome.
He is.
Yeah.
He was a district judge in Dallas for years, and he's a great lawyer.
He is a great lawyer.
And
I had my ass handed to me. I was wrong
He's doing a very, very good job for his client in that case. And, we watch it just kind of from an overview, type thing, but we don't know the intricacies of all the preparation he's put into that case and all the things that are going on inside the courtroom. We may go by if we're in the courthouse and just kind of peek in and watch a little bit of the trial, but not enough of it to know whether they're doing a good job or bad job. But we know Bubba well enough to know that he's doing a great job for his client, for sure.
Yeah.
How often do your clients take the stand when they're the defendant, and what is the process behind you trying to figure out whether that's a good thing or not?
Most of the time, defense attorneys do not want their clients to hit the stand, but I'm a little bit different on that. I think that it's important for them to hear from the client, especially if they're accused of something really egregious. So if possible, I will have my clients up there probably 60% of the time.
Oh, wow.
Yeah.
That's a lot higher than I thought.
It's not normal. It's not normal. I'm not normal.
that is unusually high. Yeah.
What would it be for you guys?
Much, much lower, because now Heather, though, when she does, I think you'd agree, when she does put her clients on the stand, they are so well prepared that there's little chance that they're going to get crossed up. But that's the problem. A witness who's not a defendant, who says a couple things, makes mistakes a couple times, you can that's not a problem, really. But if a defendant says one thing that is inaccurate, or makes them look like they're being dishonest, that could be fatal.
Yeah. How many hours you go through with them when you do prepare them for that?
Countless. And in general, just as a general rule, when we go to trial, the state's burden of proof, they have to prove the case beyond a reasonable doubt. The minute the defendant hits the stand, the burden just by human nature shifts to the defendant. Even if they say they're not going to, the jury says, I'm still holding the state to their burden. They now look at the defendant and go, do we like him? Do we trust him? Do we believe him? And by human nature, the tide has shifted to, is this someone we believe? Is this someone we like? Or can we find him not guilty just based on his body, the way he's holding himself, the way he's answering questions, the way he, what do they say, 80 or 90% of all communication is
nonverbal.
Yeah. And so that's a large, large burden to place on someone when they get on the stand. And, of course, Heather, go ahead.
No, I just had to
interrupt me anytime you want. No, please, stop.
Sustained.
I had a case. I had to try it 3 times. I did not put him on the stand the first time. The jury was split 6-6. The next time I did not put him on. It was 11-1 for guilty. The third time I put him on, it was not guilty very quickly. And so that's one of my benchmarks. Yep. You know what I mean?
Yeah, so it made that big a difference. Or do you think did you have vastly different juries there too?
No, it was. I mean, it was honestly kind of the same type of jury, but he just came across so well, and I was just scared to death to put him on the first couple of times that I chose not to. And then, I just was confident in him. We prepped him well enough, and he did just a marvelous job. So it's good.
What percentage of your clients who get sent up the river to Gen Pop do you go visit?
Well, that's Joe's.
Joe has a lot.
He's the lawyer who brings flowers.
Joe's
All of them? No, I'm kidding.
Joe's an expert in that area. Joe's a parole lawyer. Does a lot.
No,
more
I do a lot of post conviction parole stuff as part of my practice. So I go to the prisons a lot.
All right.
Yeah. So.
What's that like, by the way? Stepping foot into prison. What are the conditions like? Because, again, that's something our perception is what we see in TV and movies. What's it really
Gordon's
like?
the only one who's been in prison.
Yeah, he's the only one
That's right.
In Green Bay.
I served hard time in Green Bay.
Hours.
The parts of the prison I go into for visitation is not the part of the prison where most of the inmates are. Obviously, there's glass, yes, between us. There's security to get in and out. They're very cold, unwelcoming places. You wouldn't want to be in them. But for visitation, it's not that bad, really. Of course, I get to walk out, so that's easy for me to say. Mm-hmm. But they're generally well kept, clean. They're just big concrete blocks with with a lot of bars and thick glass. So. It's not
pretty
scary if that
depressing.
if anything were to happen. One thing about going into a prison, though, they don't going in. This doesn't happen very often, but they don't negotiate if you're taken as a hostage. That's kind of the policy. So
wow,
if something happens and you're in there, you're on your own. So
hey, this comes up a lot. The appeals process. So you lose a case. Automatic appeal always, or is it up to the client, or how does that whole thing unfold?
It's up to the client, and depending upon the sentence, depending upon the type of case it is, I can tell you this from experience: if you lose, unless something massively egregious happened at trial, some law was broken, some rule was not followed, especially in Texas, you're done. Mm-hmm. I mean, just in general, would y'all agree with that?
I do.
Yeah, I mean, the appeals process is just not, you always say, well, we're going to appeal that. You're not going to win. It's just not going to happen. That's just in general. Again, misdemeanors, we've been talking a lot about these really serious, offenses because that's the stuff that people want to talk about. The misdemeanor stuff, the smaller stuff, is not nearly as exciting and sexy. But the heavier stuff where people go to prison and they get big sentences, they're always going to appeal, but unless something really bad happened during the trial, evidence was hidden or something like that happened, the appeal just because you don't like the sentence, you ain't going to win on that.
Yeah.
What about some of the high-profile, docuseries that everyone has watched? The Staircase or the Making of a Murderer? Any of those that you guys watched, and do you have like an opinion on the Stephen Avery case from Making a Murderer?
I watched The Staircase and Making a Murder. I would probably all do this, but after I watched them, I ended up getting online to see what else was really out there that they didn't present in the documentaries, because I know they do that. They do it for entertainment, and there were things in each of those cases. I think there was something about a fingerprint on the hood in the Making a Murderer case on the car. I don't want to get bogged down in the details of that, but there was some. So they're enjoyable for entertainment, but I do know
they're always more complex than even
much
a 10-part series presents to you.
But well done and very entertaining for sure. The Staircase especially, I thought that was excellent.
That's a really good one. But what about like Brendan Dassey in Making a Murderer? That's the nephew of Stephen Avery, who he had that confession that he gave cops that he does look like he's a very slow kid who's just trying to get something over with, and that conviction keeps being upheld.
That's a tough one because he was very detailed. I don't know if you remember in his confession, there were pictures that he drew of the victim and how they went about committing the offense. And the physical evidence tended to substantiate the
his account
confession or the statement that he gave to them prior to his withdrawal of that statement. Now, I think it was really ham-handed how it was, given. But that's a tough one. That is a really tough one because if he was Go ahead. I'm
No, I
talking
was
too much,
wondering,
Heather.
did
You're
he have a
looking at me
lawyer
like
at the
I've
time?
started.
He didn't have a lawyer at the time, right?
When he was
he did,
speaking
yes.
to officers, yeah.
Was he in there with him?
No, he was not when he was speaking with those officers.
Not when he was speaking with the officers, but when he gave the picture and the other things, he was with his attorney at the
really
in the interview. If I remember correctly, I think that's right.
So in those kind of, how many of you have worked on the prosecution side before you became criminal defense?
I did.
Todd,
Heather, did you?
I did municipal prosecuting.
Oh, that's big time.
same.
No, I did for 3 years. Yep.
And what is the difference there emotionally to you? Did you find one better than the other? I know you get paid better now.
That emotionally is a big deal. Yeah, that's right.
Right, but
it's always easier to say you're wearing the white hat and you're fighting for truth and justice and the victim, and but I didn't find one to be more satisfying than the other. I enjoy being a defense lawyer. I think you have more freedom to think outside the box, to be able to come up with creative solutions to problems. I enjoy...
You enjoy the chess match more from this side.
I enjoy being dropped into the middle of someone's life, and you don't know them, and an hour later they're relying upon you to, come in and save the day. I think that there's something satisfying about that. Do y'all agree with that as well?
Yeah, I think that it's David versus Goliath. Which one do you want to be?
Mm-hmm.
David to me is the state, and the chances are that you're going to win. Unless everything is against you, you're probably going to win your case. Whereas the defense, you've always got the uphill battle, underdog. So I like being the underdog.
Mm-hmm.
Do you guys welcome a really high-profile trial because it gets your name out there and all of that? Or is that something that you wouldn't like because all eyes are on you, and if something goes wrong, then that could be bad for your reputation?
Twofold. Yes, it's good for you and your reputation, to get your name out there. But, yeah, all eyes on you and everything that you do. If you're playing to the cameras, or talking to the press, are you really representing your client? Are you really taking care of your client? Mm-hmm. So, it's a healthy balance between, I want my name out there. That'd be great. However, it could hurt the case. But
do you consider playing to the press kind of part of your defense, even though the jury is not supposed to be paying attention to, in a high-profile case I'm talking about, obviously no one's covering somebody's speeding ticket or whatever, but,
Y'all covered Dan McDowell's speeding ticket.
There you go.
Speaking of that, I've got a ticket I need to talk to somebody about after this is over.
But can't community sentiment affect a jury?
If it's that high profile of a case, for sure it can. I do believe that it can, but it's pretty rare. Most people, they tend to stay in their own little cocoon, right? Even a case you think, oh my gosh, everybody's going to know about this. They really don't. This is a first capital murder trial where the state of Texas is going for the death penalty in Collin County in the last 15 years. It just hasn't happened under this administration. That's a really big deal. This case has been consuming their office for a long time. I'll bet if you took 100 people off the street in Collin County, 95 of them would have no idea that this case is even going on. It's just not on people's mind. They care about their own lives and what's going on with themselves. It's just not that important to them.
But the Amber Geiger case was huge,
that was a big
right?
deal, right?
This has been great. This has been fascinating. Thank you all so much for the time this morning.
You don't want us to do the 840 bit?
If you've got an idea,
you're ahead of us.
After 25 years, we need ideas. So if you've got one, please
Heather was
stay.
working on her voices back here. I don't know. She's ready.
Todd Shapiro, Heather Barberi, and Joe Padian, we can't thank you enough. We appreciate it. This was wonderful.
Great. Thanks for having us.
Thank you.
Appreciate it.
That's our criminal defense lawyer roundtable. It's 8:34 on the ticket.